The second attempt to replace and modernize Canada's federal privacy law is dead. But we'll be okay. We still have the Personal Information Protection and Electronic Documents Act. And long live PIPEDA. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. I've been practicing privacy law in Canada for as long as our federal privacy law has been in effect. When the Governor-General prorogued Parliament on January 6, 2025, parliamentary business didn't only grind to a halt, everything was vaporized. This includes Bill C-27, the Digital Charter Implementation Act of 2022. The bill has a much less catchy long name, an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act, and to make consequential and related amendments to other acts. It was intended to do exactly what it says on the tin, to create a Consumer Privacy Protection Act to replace our existing privacy law. It would create a Personal Information and Data Protection Tribunal with an oversight role related to the privacy law. The bill also included the much criticized Artificial Intelligence and Data Act, sometimes called ADA. As an aside, if they hadn't included ADA in Bill C-27, the privacy law portion likely would have been passed ages ago, and I'd be talking about different things. Now, I did a full video on Bill C-27, which I'll link to below, but in a nutshell, it was supposed to do the following. It would have taken PIPEDA's accountability principle and turned it up to 11. Every organization that's subject to the law would have to have a documented privacy management program. That written program would then have to be provided to the Privacy Commissioner on request. The bill would have given the Privacy Commissioner of Canada order-making powers, and the tribunal could impose eye-watering GDPR-level penalties. It also included a number of new consent exceptions modeled on some of the ones from Europe's General Data Protection Regulation, but they unfortunately weren't the same. We have this really bad habit of borrowing ideas from Europe and then implementing them in a way that makes them incompatible. Bill C-27 was the second kick at the can for privacy law reform. The bill was very similar to 2019's Bill C-11, which was tabled as the Digital Charter Implementation Act of 2019, and which languished in Parliament until dying when the federal government called the last election. And all this follows years of many people calling for significant privacy law reform in Canada. The usual refrain is that PIPEDA was written and passed in the late 1990s, so it must be out of date. That's like 25 years ago. They point out that back then there was no Facebook, no YouTube, no targeted advertising, virtually no biometrics, and no large language model artificial intelligence. So how can you expect such a dusty piece of legislation to keep up with modern technology and modern society? Many have said we should just adopt a European GDPR, but mainly what they're looking for is big penalties and giving the Privacy Commissioner the power to impose orders. In my view, PIPEDA works as well now as it did in 2001. In its distinctively Canadian way, PIPEDA remains relevant and I think sufficient. So let's look at it. PIPEDA is based on 10 principles taken from the Canadian Standards Association Model Code for the Protection of Personal Information. The standard and the principles are all a model of technologically neutral drafting. It's based on reasonable purposes, notice, and consent. Even the safeguards principle is technologically neutral, stating that information must be protected by measures appropriate to the sensitivity of the information. Now, of course, what were reasonable, appropriate technological safeguards in 2004 are very different from the current state of play 20 years later. What is appropriate will always be evaluated in the present tense in light of changing technology and changing threats. The law was updated in 2015 with the addition of data breach notification and reporting requirements, which in my view was a key modernization. But as I said, most privacy advocates and the Privacy Commissioner are calling for huge penalties. After a long time of being satisfied with the ombudsman model, the last few privacy commissioners have expressed the view that they need the ability to levy fines and issue orders. The immediate past Privacy Commissioner actually testified in front of a parliamentary committee that every infraction must be accompanied by a penalty. I don't think they've fully made the case for this, and all the commissioners since 2001 have hardly used all of the remedial tools in their toolbox. I also think we need to be careful about this and ask ourselves whether the evidence is there, whether the PIPEDA model is actually broken. And if we're going to have orders, fines, and penalties under Canadian privacy law, how could we do this in a way that's consistent with the fundamental values of our legal system? PIPEDA is based on the particular model where the commissioner is an ombudsman whose job is to investigate complaints, solve problems, and it's up to the court to issue orders and order compensation. Anyone can complain to the commissioner, and the commissioner has to investigate. The commissioner can also investigate on his own initiative where there are reasonable grounds to do so. He can also fully audit an organization if he believes the organization has contravened PIPEDA, but to my knowledge, his office has never used this power. In the course of an investigation, the commissioner has very strong powers. He can enter any premises other than a dwelling without a warrant. He can require the production of records. He can compel testimony under oath and can accept any evidence that would be otherwise inadmissible in a court of law. In short, he has more powers than the police to investigate. But they seldom use these powers because they generally don't have to. In practice, the commissioner's investigators reach out to the organization, find out their side of the matter, look into it further, ask questions, ask for records, and try to find a resolution that's satisfactory to the complainant and the commissioner. In most cases, the commissioner does not have to use his coercive investigation powers because the organizations generally cooperate and are looking to have the matter resolved. The end result of the investigation is a report of findings, which is generally a resolution that's mutually satisfactory to the commissioner and the other parties. According to the OPC's annual reports, the matter is not resolved until the commissioner is satisfied with what the organization is now doing. Of the commissioner's published reports of findings, there are only 6 which I could find which were deemed to be well-founded but unresolved. Well, PIPEDA has a solution to that, and it's one the OPC has hardly used. If the commissioner is not satisfied at the conclusion of an investigation, the next step is an application to the federal court for an expedited hearing. At the court, the judge will review all the evidence from all the parties and make his or her own conclusion as to whether PIPEDA has been violated. The commissioner very seldom takes this route because he rarely has to. But when he does, the majority of cases that I'm able to find are ultimately settled before going to a hearing. And you don't settle a case unless you're satisfied with the outcome. So settled cases mean that the matter was resolved to the commissioner's satisfaction. One example is a 2017 investigation into a company that publicized information about delinquent debtors. The commissioner found the matter to be well-founded and unresolved. So the commissioner started an application in the federal court and the respondent company caved. The commissioner discontinued the court application and the process worked. The 2019 investigation into Facebook and the Cambridge Analytica scandal is still in the courts as Facebook is seeking leave to appeal to the Supreme Court of Canada. There's also the 2024 investigation into ALO, formerly called MindGeek, and their compliance with PIPEDA in their operation of Pornhub and other similar sites. Now, that was found by the commissioner to be well-founded and unresolved, but I have no idea where that stands. MindGeek initially sought judicial review of the commissioner's finding, but that court application has been discontinued, and I don't know where it stands. This lust for penalties can be seen in the Tim Hortons mobile app case, where the commissioner started an investigation on his own accord after reporting about the app's location tracking came to his attention. The commissioner, along with a number of provincial counterparts, investigated and issued a report of findings in which they concluded the company had violated PIPEDA and provincial privacy laws. But the company addressed the issue to their satisfaction. Problem found, problem addressed, problem fixed. The law worked as it was designed to. But the now former commissioner used it as yet another example of why he needed to be able to issue punishments and penalties. And I think we're seeing a more general thirst for blood among commissioners and privacy advocates. Whatever follows the demise of Bill C-27, I'm pretty confident that we will be seeing penalties and orders. I have some thoughts on how this should be done. I've been paying pretty close attention to this stuff since PIPEDA came into effect in 2001, and I've been involved in many investigations by the Privacy Commissioner. Under the current scheme, an investigation is surprisingly cooperative. Where it's clear that the Commissioner is seeking a resolution, and hopefully a fully negotiated one, the parties are focused on the solution and not on accusations and defensiveness. Now, that will change completely once an investigation turns from a problem-solving exercise into one where the commissioner is looking for ammunition to publicly punish the organization. I think the whole process will be turned on its head. And in my view, that will be very problematic. The issue is that if you give the investigator and the prosecutor the power to impose punishments, you're implicating some pretty important principles of natural justice. It gets a bit worse when the police and prosecutor are also given an educational and advocacy role. And then throw onto that the ability to issue guidance on what they think the law says and means. In our criminal justice system, you have the police who investigate crimes and prosecutors who prosecute the offenders. But they get a hearing in front of an impartial judge. In the current system, the Privacy Commissioner investigates, tries to resolve the matter, But it can be sent on to an impartial judge to have the final say on whether the organization has violated the law and should be ordered to change its practices. The usual rules of evidence, due process, and procedural fairness kick in before the court. The model espoused by the Privacy Commissioner recently would dispense with this important structural protection that's essential to fairness. He would get to be the cop, and maybe even the complainant, the prosecutor, the judge, the jury, and the executioner. And maybe you'd have a right to appeal to a judge, but the commissioner's finding would probably be considered presumptively true. And I've seen in the past that the commissioner has been very wrong sometimes in interpreting his own statute. We've also seen the commissioner try to shoehorn concepts like the right to be forgotten into the existing statute. We're all better off, I think, if the final word on interpreting Canadian privacy law is left to the courts. Overall, since it came into effect in 2001, I think PIPEDA has been remarkably resilient. Its rules make sense, are well understood by organizations in Canada, and I think it gives the commissioner enough tools to do his job effectively. I don't think anyone has any idea whether privacy law reform will be a priority for the government that takes over after the next election, so the resulting reality is that we're stuck with PIPEDA, at least for the foreseeable future. Long live PIPEDA. If you've made it to the end here, you're likely someone who should subscribe to this channel. I try to put a new video every few weeks or so if you're interested in this sort of content, please click the like and subscribe buttons, and there's a bell thingy to get notified of new episodes. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.